Hey everybody, welcome back to the Law News Network. I'm your host, Jesse Weber. We are in a lunch break in the Adam Matos case out of Florida. We expect testimony back at around 12:15 today, and as soon as we do have our live coverage, we'll make sure to turn to it right then. We saw prior testimony in this case. You saw the opening statements by the prosecutor in this case, and I want to talk a little bit more about the details of what we have seen and what we can expect in this case. So to help me talk a little bit more about it is LawNewz's own Aaron Keller. Aaron, great to see you.
Good to see you, Jesse. Look, it's November. You've got the tweed out already. The weather's getting colder. You're properly attired. I'm wearing the same blazer.
I can only do what I can do with what I have, you know? This is what it is. Let's talk a little bit about some of the details that we don't know yet in this case. I know that you've been looking through the trial record, you're looking through some of the depositions. We're in the beginning stages of this case. I just want to explore with you a little bit, what can we anticipate moving forward, or what do you anticipate moving forward through some witnesses that we're going to be seeing on the stand?
Well, the big witness that the state needs to get on the stand, and it'll probably be lengthy testimony, is Mr. McCann, who is one of the neighbors. He's the one who incessantly connects dots that the defendant was at the scene the day after, and then the day after that, the day after that, the day after that, and they had all of these interactions in the days after the murders were believed to have committed. Now, why is that important? It's important because the defendant told investigators, and then later said in a recorded interview with a local newspaper, that he left the scene not long after the domestic violence call on the 28th. Well, okay, why do the neighbors keep seeing him around? And why does he continue to communicate with this particular neighbor, this Mr. McCann? That's going to be really critical testimony. That's going to really line the state's case up the way that it should be lined up. This is a strong case for the state, and he's one of the reasons it's strong.
You know, Aaron, I'm gonna give you a compliment right now, so it's a good thing we're recording this and everybody could hear this. You wrote a terrific outline of the case, a terrific timeline of the events leading into this case, and anybody who wants to see it, go to lawnewz.com and you can look up a timeline of the Adam Matos case that was created by Aaron Keller here. And one of the interesting things is there were some details that, like you said, we're going to expect to hear. And one of the things from Ryan McCann is that he's going to testify, or maybe will testify to, is that Matos has used bobby pins to pick the lock before, and that begs the question, is he able to get into areas that he might not have been able to get into to begin with? And it gives the question of, how did he get back in to the Browns' home? Because as we know, there was that domestic violence call, but at some point, it's believed by the prosecution, he came back. And I'm very curious to hear about those kind of details that will really provide the jury with a little bit more of a color to who this man really is.
Well, look, I mean, he lived there, so he probably just turned the key on the knob.
But maybe they locked him out.
Well, maybe. I mean, we could speculate about it from here until the end of the day and probably wouldn't get any closer to the facts.
Yeah.
But here's the thing. Look, I mean, it's another one of these bizarre circumstances that just happens to attach to this defendant. We know that from the local newspaper reporting up in Pennsylvania, where Matos, the defendant, and the Browns used to live, that he's been on some crime sprees up there related to breaking and entering a number of residences, including one of a former girlfriend of his. Okay, that's in the criminal records from Pennsylvania as reported by a local newspaper there. Okay, so look, you've got all of that. He's been busting into places, breaking into places, presumably, possibly picking locks in Pennsylvania. Then he goes down to Florida. This neighbor gets locked out of his place. And Matos just takes a couple bobby pins and bam, he's in. I mean, this is just a fact that seems to attach to this defendant. Does it mean that he tried to, you know, get into the Brown home after potentially being locked out? I don't know. I mean, that would just be a theory, but it's just another one of these bizarre things that surrounds this case.
You brought up his past record with the police. Do you expect any of that to be introduced? And we know there's a danger of introducing prior bad acts in a way. Maybe you could just touch a little bit about what, if any, of these facts might be brought into trial.
Well, unless he testifies, I would expect very, very few of them to be, because, look, we harp on this all the time here on LawNewz, and you know this just as well as I do. There's a general prohibition against bringing these other bad acts in, and it's rooted in the pretense that someone should be tried for a crime once, not twice, and if they get convicted of this crime and they've served their punishment, there's at least a supposition that they have been reformed and that they shouldn't be dragged through the mud again on that old crime. A couple of reasons behind that. One, I mentioned, try people for crimes individually. Second, it gives someone who has been convicted an opportunity to reform his or herself. Another reason is because we don't want police just going around rounding up the usual suspects. Oh, we've got a murder over here. It was probably the guy that committed the murder down there 2 years ago. Let's just arrest him and try to throw
Which is
stuff
what we
at the
see
wall.
in so many cases where that's put in by the defense, that they needed a suspect and they just go after the first person that was the bad guy in the community. But
Yeah,
it's a little different here.
And so you've got a general prohibition. There are exceptions in it if there's a routine, a plan, a scheme. And look, we just saw that here on LawNewz on the Jeffrey Willis case out of Michigan. We saw all of these other bad acts coming in. The federal rule is 404B. Okay, different states have different versions of it. And even though some of the states follow the same language of the rule, some of them interpret it a little bit differently. Because in a lot of states, they just don't like to bring it in unless it's clear that there was an actual crime spree happening on a particular day. Other states will broaden it out and say, well, if it's at least tied into the same motive, if someone is looking for the same opportunities to commit crimes, they'll try to bring it in. So from my perspective sitting here, there's a bit of a disconnect between the various states and the federal rule as to when to apply it and when not.
Yeah.
In this case, I'd be really surprised if we saw stuff from Pennsylvania come in. It's separated in time. You're talking about different people, different circumstances, different years. To get that in Florida would be a very big surprise to me. The only way I could see it coming in is if he made the foolish decision to testify, because then it'll come in not as proof that he's in line with being a bad character, but it would come in to impeach him as a lousy witness.
Let me tell you something, Aaron. I have to tell you, I'm surprised by what the defense is doing so far. I mean, they've reserved their right for an opening statement. They haven't really gone deep into cross-examination as of yet. So would it be out of the realm of possibility that they bring this guy into the stand to try to explain what his actions were after August 28th? Possibly, maybe. I mean, there's so many dangers to putting him on the stand, but you have a guy here who was not truthful about the last time he was at the house, that was apparently living in the house, ordering pizza to the house, trying to clean up, using the debit cards, debit cards, buying a shovel. I mean, so many facts.
Driving their van to get the shovel.
Exactly. Yeah. So my issue is with this case, and I think for the defense here, is if this was a case where Mr. Matos had committed the crime, but then immediately called the police, there might have been a different kind of case than we have all of the events leading after that August 28th date, which is really what the prosecution's harping on. And I'm curious, is like, what if this was, if you didn't have all of these events taking place after that August 28th event, you would imagine it would be a totally different case. Am I right?
Oh, yes. I mean, we sat around here a little bit earlier and said, okay, well, what if this had happened? What if that had happened? You know, look, if he had called police right away and turned around and said, hey, look, I was involved in this altercation earlier, and then I tried coming back home. The family blew up on me. It led to physical blows, and then this attack escalated. He probably would be facing some pretty serious charges, but, you know, would it be this first-degree premeditated death penalty?
Maybe not.
Maybe not. I mean, yeah. and then, look, that's arguable. But look, usually we reserve these death penalty cases in the states that have a death penalty for the most egregious crimes. And why does this crime look egregious? It's because of the cover-up. The cover-up just leads inquiring minds to kind of backpedal and say, what really went on? Was this some kind of like really brutal attack where this guy left the domestic violence, said, you know what, I'm going to get rid of these people, planned it out? I mean, how did this thing roll out? And because there was a cover-up, a lot of people just want to backpedal and say the attack itself must have been horribly vicious. Now, it's possible that one thing that the defense could argue in this case, once the defense starts to put some kind of a case on, because they've been eerily and strangely silent up until now, I'm assuming that they're strategizing something, or at least I hope, but they might turn around and say, look, this guy was in a pressure cooker situation. He's brought down to Florida by this family that doesn't want to move down without him being present in his son's life. So he kind of goes down, maybe against his own, better thoughts. He's kind of swept into this. He goes down there. Then they're harping on him to get a job. We know that from the pretrial records. And there were some difficult conversations attached to that. I don't know what he was doing in Pennsylvania. Maybe he had a job in Pennsylvania. Maybe he was struggling to figure out how to fit in Florida. I don't know, but the picture could be painted that, based on what we know from the pretrial depositions, that maybe Greg Brown is getting down on him. Megan Brown is not happy with the disagreement that they're having over how to raise the child. And when there's one instance in the depositions where Megan asked him to do one thing, Greg asked him to do another thing, and it led to this big blow up, to the point where then Greg is getting in the middle of this fight, and it's like you can sense that there is tension in the air. And look, I will admit that there are some family members who say, oh, this wasn't rancorous, but it could be painted that way or colored that way. And if the defense were to do that, which might be what they're going to do, I could see this sort of turning into more of a pressure cooker, heat of the moment, everybody blows up.
So in other words, not first-degree murder, nothing like that, but more of a horrible, horrible
passion
crime
or something.
of passion.
I mean, look, maybe they're just going to try to knock it down, either from the death penalty down to life, or they're going to try to edge it down from first degree down to second degree or something. I'm trying to figure out how they're going to play this thing, and there are enough nuggets in there for them to potentially do it. Do I think it's a really good defense?
If they do that, don't they need to bring him on the stand to do that, though? To really say, he was the guy who was there, he could testify to what happened, what was really going on. I mean,
well, then all the prior bad acts are going to come in.
Absolutely,
I think that they can do it with what they've got out of other people who were witnessing the relationship going on in that household.
I got to say, I was surprised that Jeffrey Willis went on the stand in that case, but he went on the stand. Didn't really work out in his favor.
No.
He was convicted all around. But I'm curious about. I'm not 100% sure as of yet what the defense is going to do, obviously, and I'm not 100% sure if they're not going to put him on the stand, because I think there might be a possibility. Could be wrong. We'll have to see. The idea that we talk about that possibly there was another person who was implicated in this crime. We know that Mr. Matos conducted a Tampa Bay Times interview while he was in jail. Probably not a great idea. That's going to come out into trial. The idea that he was pointing the finger at somebody else, the defense can still wait for that argument and bring it up at a later date. Do you think they might do that?
Yeah, I mean, we've got a couple of possible third-party suspects coming into play here. We've got this woman in Kansas who was entwined with Nick Leonard, who was the guy who, in some accounts, was Megan Brown's new boyfriend. So they both get killed. What's up with this person in Kansas? Right before he's killed, he calls Kansas and complains to the woman's boss and says, this woman's stalking me. She works for you. You're Verizon. I think she's using your company records and assets in order to get into my accounts and potentially to harass people who are close to me. Megan Brown is getting calls from an unknown woman who she then calls police to complain about. So it's just kind of like, what's going on here? There's a lot of what ifs here, and some cases we hear third-party suspects, oh, maybe this person was on, maybe that person, maybe it was somebody else. Well, in this case, we've got some hard, tangible evidence. We know that Megan Brown made a report to police. We know Nick Leonard complained to the Verizon folks in Kansas. These are things on the record. There are emails, there are phone calls. We know something was going on between Megan Brown and Nick Leonard, two people who were murdered, that they were making complaints about interference that did not have anything to do with Adam Matos, so far as we can tell, in the days leading up to the murder. Now, maybe it's a horrible coincidence, and the better part of me suggests that that's just all it is, that these people just led entangled lives and that it's a horrible coincidence. But it's enough for a defense attorney to work with. And I'll say it again for people listening, if they're saying, oh, Aaron, this guy's guilty, there's a ton of evidence against him, what are you talking about, third-party suspects? Well, I don't think that it's strong enough to override the burden of proof here. But there's enough there for the defense to work with at a minimum. There is enough there to put on a defense of a third-party suspect if the defense decides to go there. The pretrial documents suggest that they spent a lot of time looking into it.
Let's talk about, I mean, have you found anything about actual physical DNA evidence as of yet linking Mr. Matos to this crime, his DNA on any of the weapons, his DNA on any of the, the hammer, anything like that, anything that would say that they would place him at that crime scene? We know he was in the house, but if it's not past the realm of possibility that this is a guy who maybe wasn't the actual trigger man and the one who actually committed the crimes, do we know anything as of this point about physical evidence tying him to this crime?
Not that I have seen, but I will say that with the caveat that the record is hundreds and hundreds and hundreds of documents long. That's not even counting pages. Some of the documents are 50+ pages apiece.
Right.
I've read a lot of it. I haven't read all of it. And a lot of the DNA evidence wouldn't come up in some states in the publicly available record prior to trial because it's something that would sometimes be filed under seal. There were a lot of records filed under seal in this case that are just barely starting to come out because we're talking about them at trial.
Yeah.
So I'm scampering around reading what I can get my hands on, but it's not as full of a record as it would be, for instance, after trial when it all is going to be public at that point.
Aaron, you're a great attorney, so I'm going to ask you this question. I asked it of Deborah Blum. The idea that, if you're a defense attorney, you're representing Mr. Matos, and you hear it's accepted as fact that, okay, he was at the house, he was living at the house, he was ordering pizza, he was hanging out with Ryan McCann, living as if nothing was going on. Defense attorney would be like, oh, that makes my client look pretty guilty. Is there any way you could switch that around and say, well, wait a minute, not necessarily. We might be able to use that to our advantage maybe on a later part of the case, maybe if he is convicted, if it does turn to the death penalty phase and show that this is a guy that might not have been, had a mental deficiency of some kind, that there might have been something off with him, or twist the facts in a way and say, listen, he didn't act like anything was wrong because he didn't think anything was wrong, and maybe when he didn't know that there was a murder. I'm just trying to tweak it out a little bit in the sense that those are such hard facts for the defense to argue away, that this is a guy who was living at a crime scene. Is there any way that they might be able to use that to their advantage at some point, either in this part of the trial or the penalty phase?
Not that I can think of. I haven't been able to think of that. And you said you were trying to tweak the facts out. For a minute, I was worrying that you were tweaking out because I'm just like, I don't think you can argue out of some of this stuff. It's so bad. I think it's so hard to argue out of. The only thing I think they could have done is to argue some kind of mental disease, defect, some kind of, he snapped, he went nuts. But that's what I was saying a little bit before about this pressure cooker kind of situation. Sure. And I'm not even sure that that's exactly what existed there because the pretrial depositions could read either way. But it's possible, there's at least enough there to argue it. In a lot of states, you have to give notice before you go that route. And I'm not aware that they've given notice in Florida to go that route. If they have, I haven't found it yet. Okay, so, and I'm not sure what the notice requirements are in Florida. I don't have a law license in Florida. Maybe they can do it last minute there. I just don't know. But I mean, looking at the possible avenues, I sense that there could have been three if I got this case at the beginning. One is third-party liability. Somebody else did this. The other is mental disease, defect, he snapped, something like that. The other one, is to try to, it's kind of the same thing though. I mean, one is mental disease defect, the other is, I have to separate these. The third one would be that he, snapped in this pressure cooker kind of situation. Those are the only three avenues I see here. And I can't figure out which way the defense is going to go. Yeah. The documents that I've read thus far would suggest that at least at one point, the defense was barreling down this road of going third-party liability. Whether that's going to play out here, I'm not sure. There may be an evidence rule in Florida that's suggesting that the state, that the defense kind of holds this back because it would give the defense the first bite at the apple. And then the defense can stand up and say, okay, you've heard all this stuff in the state. Guess what? We think another person did it, and we're going to prove that to you now. Yeah. And it would potentially, depending on the way the rules of evidence are written in Florida, deflate the state from trying to refute that argument before the defense puts it on.
That's
different
an
states
interesting
do that different ways.
Yeah, that's an interesting way to look at it. And again, we are speculating here about how the defense will move forward and see how this case moves forward, because we are really in the beginning stages of it. And Aaron, thank you so much for being my guest today. But now you're going to jump in and be the host for the day.
You're going to be my guest?
I wish I could, but I have to take
Oh,
off.
listen.
I'm sorry.
To
You got to book me up. You got to book me up.
What do you have to? I have
to now find my everyday blazer like you. But Aaron, thank you so much.
Okay.
We are going to be switching out, so Aaron Keller will be taking over the hosting job, and we are covering the Adam Matos case. We expect live testimony in about 10-15 minutes. They will be finished with their lunch recess. As we are talking so much about the prosecution's case, I want to begin right now by playing you a clip from the beginning of their case. They called Deputy Dustin Brooks. He was a 911 operator who you basically will hear the phone call that Megan Brown did make to her in regards to the threat when Adam Matos threatened her with a knife. So let's listen a little bit about that, because that is a key piece of evidence by the prosecution against Adam Matos. So let's begin with there, and thank you for joining me, and Aaron Keller will join you in a minute.
What was your